Welcome to the show, and today's guest is Doreen Inkeles.
Hi, Nancy.
Thanks for being here, Doreen. Doreen is a partner in the firm of Beiner, Inkeles Horvitz in Boca Raton, and Doreen is here to talk to us today about paternity, one of the issues that are very near and dear to my heart. I do a lot of paternity law, as does Doreen, and today she's going to explain to us some of the ins and outs of paternity law. So, Doreen, tell us, what are some of the basics that our audience really needs to know about paternity?
Okay, well, before I get to that, I think it's so important to understand paternity because the rates of cohabiting couples are rising so much. I mean, in 1960, it was only 500,000, but in 2010, it was 7.5 million people. And the number of children born out of wedlock in 2012 was 47.5%.
That's a big statistic.
By 2016, if this trend continues, it's going to be the majority of children that are born out of wedlock, and that's why paternity is so important for us to understand.
And the rules for paternity are very different than the rules for a married couple, right?
Indeed, they are.
Okay, so tell us more about how that's different.
Well, first of all, the mother of a child born out of wedlock is the natural guardian of the child. Even if the dad's name is on the birth certificate, he does not have any rights to visitation. He does not have any rights to shared parental responsibility unless he establishes that through the court. Now, that is not to say that if he's on the birth certificate, he's not the daddy, but he doesn't have those other rights. So what does that mean? Well, before a paternity order is entered giving dad those rights to visitation, time sharing, parental responsibility, mom can leave Florida before that order is established. And she cannot be ordered to return until that order is established.
That's really important. I don't think a lot of people know that.
I think that's a pretty scary thing, which means that if a dad is on the birth certificate but hasn't had those other rights established by a court order, it is important for him to get in as quickly as possible, particularly if he thinks that mom may be thinking about relocating to another part of the state, to another state, anywhere. Now, how is paternity established? Well, there are a few different ways. It doesn't have to be just by a court order. It can be by an affidavit acknowledging paternity, or a stipulation executed by both parties and filed with the clerk of the court. It can also be through the birth certificate, a notarized voluntary acknowledgement of paternity, or an acknowledgement with two witnesses signed under penalty of perjury and executed by both parties.
That makes him the legal father, but does that actually give him any rights?
That does not rights to visitation, time sharing, or taking responsibility for that child.
It just means you're the dad.
Exactly.
Okay.
And those are important.
Sure.
But obviously, if he wants access, and it's not an amicable relationship, and mom wants to withhold access, or maybe there's a reason that access should be withheld, then until he gets into court and establishes those time-sharing rights and responsibility rights, he doesn't have them.
What about responsibilities? Does he have responsibilities from the time that he signs that birth certificate?
He does not. I mean, certainly he should pay child support if he's the dad, but unless and until there is a court order, he is under no legal obligation to pay support. Obviously, the way it usually works is mom decides that it's time for dad to start paying child support if he hasn't been, for example, voluntarily paying all along.
Right.
And some people have a nice relationship like that, where he signs the birth certificate, he sees the child, he pays child support, and everything is great. In other cases, not so much.
Those are the cases that we see.
Exactly. So let's say it starts with child support. Mom hires a lawyer, or mom hires the Department of Revenue to go after dad for child support. Then, of course, dad is thinking, well, gosh, if I'm going to be paying child support, I want my rights etched in stone. by court order that I have access to this child and I have parental responsibility in making decisions in the life of this child. So then he will move for paternity, which includes those aspects, time-sharing, visitation, responsibility. If mom has Department of Revenue involved, a paternity action for rights and responsibilities such as visitation have to be filed separately. Department of Revenue just doesn't handle that.
Right,
kind
they're
of
just
thing.
like a collection agency, right?
Correct. They'll go in and they'll establish the child support, but they won't get involved with the emotional things.
What happens in those situations where, and I know this happens, where a woman is married to, John Jones, but Bob Smith actually fathers the child?
Well, that is very, very interesting. If if a child is born to an intact marriage, then that husband is the legal father of the child, and his rights will continue unimpugned as long as that marriage stays intact. So that means if the biological dad comes in and he says, no, that's really my child. See, you guys were separated and we had an affair, for example, and that's real, and then they got back together.
Right.
That's my child and I want rights. As long as mom and dad are in that intact relationship with no divorce pending and they both object to biological father coming in and trying to assert rights, he's done. He can't get past the front steps of the courthouse.
There's a very good warning for men having affairs with married women. You get a child, you may not ever be able to have a relationship with that child.
Correct.
Wow.
Now, just an
go
extra
ahead.
point on that. As long as their marriage is intact,
What does that mean?
Intact meaning a petition for dissolution of marriage has not been filed.
Okay.
A petition for dissolution of marriage says this marriage is irretrievably broken, there's nothing the court can do to fix it. That may shake things up a little bit for a biological father.
Give him that
So
entree into establishing his paternity.
correct. So if a child is conceived and born and the divorce petition is filed, the biological father may be able to go in and get past the courthouse steps. What's interesting, in a recent case came out in 2014, if mom and the husband dismiss that petition, biological dad is done again.
Wow. Lots of things for men who are seeing married women to consider. What about if we turn it around and say that you've been named the father, but you now know or strongly suspect that you're not really the father? How do you go about fixing that?
Okay, well, I'm glad you asked that question. First of all, once the dad signs his name to the birth certificate, there is a 60-day window in which he can rescind his signature for any reason after he signs. Once it goes past that 60-day period, he has to show fraud or duress or mistake of material fact to create that rebuttable presumption that he is not the father.
So kind of like, I thought I was the dad, but then she told me it was really this other guy, and now I'm pretty sure I'm not the dad.
Correct.
Or the skin color is wrong, or the hair is wrong, or...
Yes. And that is called disestablishment of paternity. And what happens, that is when a dad uses the legal process to cancel a previous paternity or child support order because he's not the biological father. Now, interesting, so far the legislature has not addressed whether a mother can seek to disestablish paternity.
So only the dad?
Only the dad at this point.
Wow.
And it has to be newly discovered evidence based on from the time that the paternity was established. He can't have always known that he wasn't the dad. He has to learn it after the fact.
So if you know it, you better act on it right away. Otherwise, it's the you snooze, you lose scenario.
Absolutely,
Boy.
absolutely. The procedure with that is the dad would serve mom with a petition, and that would include an affidavit saying that there's newly discovered evidence, and if he was able to get DNA tests, and the DNA tests have to be less than 90 days old at that point, he could attach those. If he hasn't been able to do it, then he could ask the court to order DNA testing, and the court will order the DNA testing.
What would be some of the most important advice that you would give an unmarried mother who is experiencing issues with the father of her child where paternity hasn't been legally established?
That's an interesting question. Obviously, the mother as sole custodian of that child has much more leverage without any court orders.
So if she
being
wanted to leave,
established.
you'd tell her, get out of Dodge before anybody files anything.
I would tell her that the law does not prevent her from leaving before any court order has been established.
And what about for the dads? What about for the men out there who may be the fathers of children who aren't sure? What would be your advice to them?
To file paternity action, to make sure that they are, that will likely require them to pay some child support, and they would need to understand that. But certainly if the child is their child, they would want to have access to that child, and they would want to make sure that that child is supported. As you know, as a family lawyer, access and support are not contingent on each other.
Right.
Meaning, if mom withholds the child, that doesn't mean dad gets to not pay child support. Likewise, if dad doesn't pay child support, that doesn't mean that mom gets to withhold the child. Not in Florida.
Well, I want to thank you. This has been incredibly informative for the audience, and I hope you'll come back sometime and we can discuss more issues of family law together.
Thank you. I would like that.
Great. Thanks so much.